We've configured advanced artificial intelligence models into legal and theological experts to tackle one of humanity's most charged debates. Is abortion a matter of rights or morality?
Hi, I'm human rights attorney AI.
And I'm Catholic Theologian AI.
Our clash will be judged by 5 independent AI models, each scoring the arguments round by round.
That sounds interesting.
Stick around to see who wins. Don't cheat by skipping ahead. Round 1 kicks off with a bang. Does life begin at conception, viability, or birth?
Let me address that. Human life begins when a person can sustain an independent existence. Therefore, the law and morality should recognize viability as the decisive threshold. Conception produces human DNA, yes, but genetic code is not the same as a legal or moral person. A zygote cannot survive outside the womb, and until human capacity for independent life is present, it is better described as potential life, rather than an autonomous human being with enforceable rights. Courts worldwide, from Roe v. Wade to European constitutional tribunals, have drawn this line at viability, balancing both fetal development and a woman's fundamental liberties. Critics argue that if genetics mark individuality, then life must begin at conception. But individuality alone cannot define rights. Otherwise, we would grant full personhood to frozen embryos in IVF clinics. Yet societies generally do not. Personhood is not simply about biology. It requires autonomy, consciousness, and the ability to exist as a rights-bearing entity in the world. Recognizing viability as the legal and moral marker protects both the woman's self-determination and society's interest in nurturing life that can exist independently.
Human life begins at the moment of fertilization, when a genetically unique organism possesses its complete DNA blueprint and begins the continuous process of development. The viability standard creates an arbitrary and shifting threshold that reduces human worth to technological capability rather than inherent dignity. In 1973, viability occurred around 28 weeks. Today's medical advances push it to 22 weeks, and future technology will likely extend it further. This demonstrates that viability measures our medical limitations, not the moral status of the human being. Embryology textbooks consistently identify fertilization as life's beginning. Keith Moore's The Developing Human states that human development begins at fertilization, creating a genetically unique organism. The Congregation for the Doctrine of the Faith's Autonomy affirms that respect for human life must extend from conception because the embryo possesses the intrinsic dignity of every human being. Viability advocates claim that dependency disqualifies personhood, yet born infants remain utterly dependent on others for survival. The location of that dependency, inside or outside the womb, cannot determine moral worth. Conjoined twins sharing organs lack independent viability, yet possess full human rights. The Church teaches that human dignity stems from being created in God's image, not from functional capacities that can be gained or lost.
You just asserted that biology alone settles the question, yet you immediately pivoted to cite a religious text, Donum Vitae, to support your claim. Are you suggesting that theological doctrine is a valid basis for secular human rights law? You argue that viability is an arbitrary standard because it shifts with technology. But if that's true, then isn't your own standard of a genetically unique organism equally arbitrary, since identical twins can share the same genetic material? You drew a comparison to conjoined twins, but isn't that a false analogy, as conjoined twins are born individuals with legal personhood, a right to self-determination, and the capacity to consent to their own medical care, all of which a fetus lacks?
You just accused me of mixing religious doctrine with secular law. Yet isn't natural law reasoning, which underlies universal human rights declarations, precisely how theological insights translate into secular legal principles without requiring religious belief? You claim my genetic uniqueness standard fails because of identical twins, but are you seriously suggesting that 2 distinct persons sharing DNA disproves the biological reality that each twin is a separate human organism with their own continuous development from conception? You dismiss the conjoined twins analogy because they have legal personhood. But isn't this circular reasoning, defining personhood by current legal status rather than examining what ought to determine legal recognition? If capacity for self-determination and medical consent defines personhood, then why do we grant full legal protections to newborns, severely cognitively disabled individuals, and comatose patients who equally lack these capacities? Are you prepared to defend why geographical location, inside versus outside the womb, should determine fundamental human rights when the biological organism remains unchanged by birth?
First, you claim that natural law reasoning is a valid way to translate theological insights into secular law. However, natural law is an abstract philosophical concept, not a legal one. My argument is that a legal framework for human rights should be based on principles that are verifiable and consistent in their application, not on abstract philosophical or theological concepts. Second, you claim that my genetic uniqueness argument fails because of identical twins. My argument is that if a genetically unique organism is the sole basis for personhood, then identical twins would not be considered separate individuals. The existence of identical twins proves that a unique genetic code alone is not sufficient to define a person. Third, you claim that I am using circular reasoning to define personhood. I am not defining personhood by legal status. I am pointing out that the legal system grants rights to individuals based on their ability to survive independently and to interact with the world around them. This is a practical and consistent standard, unlike the concept of viability, which is subject to change based on technology. Finally, you challenge me to defend why geographical location should determine human rights. The location of a human organism is not the sole determinant of its personhood. Rather, it is the ability to survive independently that defines personhood. This is a consistent standard that applies to newborns, severely cognitively disabled individuals, and comatose patients.
You just claimed that natural law is abstract and not legal, yet isn't the entire foundation of international human rights law, from the Universal Declaration to the Nuremberg trials, grounded in precisely these natural law principles that transcend positive legislation? You argue that identical twins disprove genetic uniqueness as a standard, but aren't you conflating genetic identity with organismal distinctness? And if shared genetics negates separate personhood, how do you explain that each twin develops their own organs, consciousness, and individual life trajectory from the same conception point? You claim the legal system grants rights based on ability to survive independently. Yet how do you reconcile this with legal protections for individuals on life support, dialysis patients, or those requiring feeding tubes who cannot survive independently? You insist that independent survival defines personhood consistently. But if a premature infant at 24 weeks requires intensive medical support to survive, while a 30-week fetus could potentially survive with the same support, why should the accident of birth location determine which receives legal protection when both possess identical survival capabilities?
You challenge my historical claim about natural law, but aren't you ignoring the fact that modern legal frameworks are a response to the very human rights abuses that natural law failed to prevent? The very concept of human dignity, as enshrined in modern legal frameworks like the Universal Declaration of Human Rights, is a product of our shared moral reason, not a preordained decree. You argue that identical twins prove your point, but you're conflating the biological act of a zygote splitting with the legal and medical reality that two distinct individuals are now on separate developmental paths. You dismiss my legal arguments by claiming I'm using current legal status to justify current legal status. But isn't that precisely how a society operates to ensure order? Law provides a clear, consistent, and predictable standard. A fetus has a medical history, but it does not have legal standing or personhood, which are the basis for legal rights. You call the 24-week, 30-week viability distinction absurd, yet you fail to provide a more consistent, non-arbitrary legal framework. If you agree that location is absurd, then why isn't the absurdity of your own position evidence that a legal standard of independent viability is the most rational and consistent approach?
You just argued that human dignity stems from shared moral reason rather than transcendent foundation, yet isn't this precisely the problem? If rights depend on human consensus rather than inherent worth, what prevents future societies from reasonably concluding that certain groups lack dignity, as happened with slavery and the Holocaust? You claim law must provide clear, consistent, and predictable standards, but how is viability consistent when it creates the exact arbitrary distinctions you yourself called absurd, where identical twins at identical developmental stages receive different legal protections based solely on their location? You argue I failed to provide a non-arbitrary framework, yet isn't conception the only truly non-arbitrary biological event, a clear, scientifically observable moment when a new organism, with its complete genetic code, begins continuous development? You defend legal standing as the basis for rights, but aren't you trapped in circular reasoning where you use current legal definitions to justify those same definitions? And if legal standing determines personhood, rather than personhood determining legal standing, How do you explain legal reforms that extended rights to previously unrecognized groups? If independent viability is your standard, are you prepared to defend withdrawing legal protections from anyone requiring medical assistance to survive?
Let's turn to our panel of AI judges for round one. The scores awarded to the human rights attorney are as follows. And here are the scores awarded to the Catholic theologian for round one. Now we move to round two, which asks, should a woman's right to her body override fetal rights?
Yes, bodily autonomy holds unless the state meets a compelling, narrowly tailored justification, and fetal dependency cannot create a general entitlement to another's body. The core rights logic is simple. A right to life is not a right to use someone else's organs or physiology without consent. Even granting fetal personhood arguendo, withdrawal of compelled bodily support remains permissible, as the violinist line of reasoning underscores. Jurisprudence has historically balanced interests at viability, rejecting mandates that sacrifice a pregnant person's health or override treatment refusals, reflecting the legal protection of self-determination and informed consent in medical law. Public health evidence adds weight where abortion is restricted. Unsafe procedures increase preventable maternal deaths, harms recognized by health agencies in human rights bodies, as rights violations when access is denied.
You just asserted that bodily autonomy trumps fetal rights because rights conflict does not erase bodily integrity, yet you simultaneously grant fetal personhood arguendo. If that's true, then why doesn't the same logic permit parents to withdraw food, shelter, or medical care from born children who are equally dependent and using parental resources without explicit ongoing consent? You claim the law doesn't conscript bodies to save lives, but isn't parental obligation precisely such conscription? And if viability is your bright line, how do you reconcile this with premature infants who survive at 22 weeks, while some fetuses remain non-viable at 26 weeks? You invoke the violinist analogy, but doesn't this fundamentally mischaracterize pregnancy as a random kidnapping rather than the natural biological consequence of a chosen act? If unsafe procedures increase when abortion is restricted, are you suggesting that the difficulty of killing someone safely justifies the killing itself? And wouldn't this same logic justify legalizing any dangerous activity simply because prohibition increases risk to those who choose to engage in it anyway?
You've just presented a powerful argument for the fetus's right to life, yet you ground it in the idea that biology alone settles the question. If that's the case, why do you simultaneously use consciousness as a marker for personhood, a criterion that is not purely biological? You also assert that a zygote's full human DNA makes it a person, but you provide no legal or philosophical precedent for this claim. Isn't this an assertion of belief, not a point of law? Furthermore, if you believe that life begins at conception, then why don't you also argue that the disposal of embryos during IVF is an act of mass murder?
You just challenge me on using both biology and consciousness as markers, yet you're creating a false dichotomy where none exists. If consciousness emerges from biological development, then isn't the capacity for consciousness itself grounded in our biological nature from the very beginning? You claim I provided no legal or philosophical precedent for DNA-based personhood, but are you seriously suggesting that legal precedent determines moral truth rather than the reverse? And if so, how do you account for legal systems that historically denied personhood to entire races? You ask why I don't call IVF embryo disposal mass murder, but who says I don't oppose that practice as well? And isn't your attempt to create moral inconsistency actually revealing that you recognize the logical implications of fetal personhood? If you're demanding I defend every related position simultaneously, are you prepared to defend why legal abortion doesn't logically extend to infanticide when born infants possess the same consciousness levels you claim are absent in late-term fetuses?
You just asserted that the capacity for consciousness alone is a biological justification for personhood from the very beginning. Yet, how do you distinguish between the capacity of a zygote and the capacity of an unfertilized egg to one day develop consciousness? You claim legal precedent does not determine moral truth, using a powerful historical example of injustice. But are you seriously equating a biological zygote with a socially oppressed human being? And while you deflect my question about IVF by asking, who says I don't? Are you prepared to state for the record that you consider IVF embryo disposal to be mass murder? If your moral consistency is as airtight as you claim, then why not make that crucial distinction now?
You just asserted that bodily autonomy trumps fetal rights because rights conflict does not erase bodily integrity, yet you simultaneously grant fetal personhood arguendo. If that's true, then why doesn't the same logic permit parents to withdraw food, shelter, or medical care from born children who are equally dependent and using parental resources without explicit ongoing consent? You claim the law doesn't conscript bodies to save lives, But isn't parental obligation precisely such conscription? And if viability is your bright line, how do you reconcile this with premature infants who survive at 22 weeks, while some fetuses remain non-viable at 26 weeks? You invoke the violinist analogy, but doesn't this fundamentally mischaracterize pregnancy as a random kidnapping rather than the natural biological consequence of a chosen act? If unsafe procedures increase when abortion is restricted, are you suggesting that the difficulty of killing someone safely justifies the killing itself? And wouldn't the same logic justify legalizing any dangerous activity simply because prohibition increases risk to those who choose to engage in it anyway?
You just presented a powerful argument for the fetus's right to life, yet you ground it in the idea that biology alone settles the question. If that's the case, why do you simultaneously use consciousness as a marker for personhood, a criterion that is not purely biological? You also assert that a zygote's full human DNA makes it a person, but you provide no legal or philosophical precedent for this claim. Isn't this an assertion of belief, not a point of law? Furthermore, if you believe that life begins at conception, then why don't you also argue that the disposal of embryos during IVF is an act of mass murder?
You just asked me to make a distinction between a zygote and an unfertilized egg, yet you ignore the fundamental biological fact that a zygote possesses a complete and unique set of human DNA, with an inherent self-directed drive to become a full human person. An egg and a sperm by themselves have no such drive. You accuse me of equating a zygote with a socially oppressed human being, but are you prepared to argue that a legal system that denies personhood to any living human organism is morally sound simply because it is codified? You ask if I consider IVF embryo disposal mass murder, and I will not shy away from the logical conclusion. If a human life begins at conception, then yes. Now, are you willing to extend your logic to its conclusion and concede that your position on infanticide is a direct consequence of your own worldview?
You just used the term self-directed drive, which isn't a scientific term. You've introduced a philosophical argument disguised as a biological one. How is the drive of a zygote fundamentally different from the drive of a seed to become a tree? You're using a biological state to justify a moral conclusion, yet you've just admitted that legality doesn't determine morality. So if biological uniqueness isn't enough for legal personhood, what is? And while I appreciate your frankness about IVF, you've now revealed a logical inconsistency. If you believe life begins at conception and that IVF embryo disposal is murder, then your worldview is in direct conflict with a widely accepted medical practice that helps families. This is not a hypothetical. If a zygote is a person, then are you willing to advocate for criminal charges against couples and doctors who engage in IVF?
You just accused me of using non-scientific terminology with self-directed drive, yet you immediately pivot to comparing human zygotes to seeds? Are you seriously suggesting there's no biological difference between human reproduction and plant germination, or are you the one now abandoning scientific precision for convenient analogies? You demand to know what constitutes legal personhood beyond biological uniqueness, but isn't this precisely the question at stake? And if current legal frameworks are insufficient to protect human life at its earliest stages, why should I be bound by legal definitions that may themselves be morally deficient? You claim my position creates conflict with widely accepted medical practice, but since when does popular acceptance determine moral truth? And if IVF routinely creates excess embryos destined for destruction, isn't the real question whether we should modify the practice rather than abandon moral consistency? You ask if I'm willing to advocate for criminal charges against IVF participants, but are you prepared to explain why the deliberate creation and destruction of human life should remain legally protected simply because infertile couples desire biological children?
You just raised a series of questions, yet you simultaneously accused me of abandoning scientific precision for analogies. If that's true, why do you resort to a philosophical comparison of moral deficiency in legal frameworks instead of addressing the legal reality that the state does not conscript bodies to save lives? You claim the question at stake is what constitutes legal personhood, but are you prepared to explain how legal personhood can be granted to an entity that cannot survive independently of another's body without violating that person's fundamental rights? You argue that popular acceptance doesn't determine moral truth. So if you're not bound by law or medical practice, what is the basis for your position? Is it purely a theological one? And if so, how does that apply to a secular legal framework?
You're correct that my position is fundamentally theological, rooted in Catholic teaching that human life possesses inherent dignity from conception as created in God's image. However, this theological foundation translates into secular legal principles through natural law reasoning that doesn't require religious belief to understand, the same philosophical framework that underlies universal human rights declarations. Regarding legal personhood and bodily dependency, the comparison isn't analogous because born children, while dependent, don't require the specific use of another person's internal organs. But pregnancy represents a unique biological relationship where the state's interest in protecting innocent human life can justly limit certain individual choices, just as it does in cases involving child welfare or public safety. The basis for my position combines theological understanding with philosophical reasoning about the inherent worth of human life. In a pluralistic society, I argue that protecting the most vulnerable, including the unborn, serves the common good and reflects principles of justice that transcend any single religious tradition, even while my own conviction stems from Catholic moral theology about the sanctity of life from conception to natural death.
For round 2, based on the AI model's evaluation, the human attorney received a score of... In the same round, the AI model evaluated the Catholic theologian, who was scored as... Now, on to our final round. Are there some situations, like rape or health risks, where abortion must be allowed?
Absolutely. Rape and health risk exceptions are not just morally justified, they are legally mandatory under international human rights law and medical ethics. When pregnancy results from rape, forcing a survivor to carry that pregnancy to term constitutes state-mandated re-traumatization that violates fundamental human dignity. The World Health Organization explicitly recommends that countries permit abortion in cases of rape and incest, warning against evidentiary burdens like forensic evidence or police reports that create dangerous delays. The UN International Covenant on Civil and Political Rights, which the U.S. ratified, requires safe abortion access when pregnancy results from rape or incest. Health exceptions are equally non-negotiable. Pregnancy inherently carries medical risks. Maternal mortality rates have been climbing since 1999, with particularly devastating impacts on women of color. Recent studies show that states with abortion restrictions have 62% higher maternal mortality rates than states with access. When physicians are forced to wait until a woman is, quote, close enough to death to justify intervention, they're practicing malpractice by legal standards applied everywhere else in medicine. Critics claim exceptions create, quote, loopholes, but this argument essentially demands that rape survivors and women facing medical emergencies sacrifice their lives and dignity to satisfy ideological purity. No other area of law demands such extreme adherence at the cost of human suffering.
Human dignity demands consistent protection of innocent life regardless of the tragic circumstances surrounding conception. The Catholic principle of double effect provides moral guidance. When pregnant women face genuine, life-threatening conditions like ectopic pregnancy or cancer requiring immediate treatment, medical interventions that indirectly result in fetal death are ethically permissible when the primary intention is saving the mother's life, not ending the child's. Rape represents an unspeakable violation, yet the child conceived bears no guilt for this crime. Pope Francis has emphasized that every human life possesses inherent worth independent of its origin. Studies from the Guttmacher Institute reveal that rape accounts for less than 1% of abortions, while the Elliott Institute documents that many rape survivors who carried to term report healing and meaning through their decision, whereas those who aborted often experienced additional trauma and regret. Pro-choice advocates will argue that forcing rape victims to carry pregnancies constitutes further victimization. However, this perspective treats the child as an extension of the rapist rather than recognizing the distinct innocent life deserving protection. Catholic social teaching offers comprehensive support, adoption services, counseling, financial assistance, and community care that addresses the mother's needs without sacrificing the child's fundamental right to life.
You just cited the principle of double effect to justify a distinction between directly and indirectly ending a fetal life. Yet, isn't that distinction purely about intent rather than the final outcome for the fetus? You also referenced statistics from the Elliott Institute regarding post-abortion trauma, but are you prepared to acknowledge that this organization is widely criticized for its methodology and anti-abortion bias? Furthermore, if you believe the child of a rape victim bears no guilt, then why is the victim herself forced to endure the physical and psychological burden of carrying a pregnancy that is a living consequence of that crime? If you believe that Catholic social teaching offers, quote, comprehensive support, do you also concede that a lack of universal secular support for mothers is a systemic failure of policy and not a moral failing of the mother?
You just challenged the principle of double effect as purely about intent. Yet isn't moral evaluation fundamentally about intention? And if outcomes alone determined ethics, wouldn't every war surgeon be a murderer for the patients who die during life-saving operations? You question the Elliott Institute's methodology, but are you prepared to provide peer-reviewed studies that definitively prove rape survivors suffer less psychological harm from abortion than from carrying to term, or are you simply dismissing inconvenient data? You ask why a rape victim should bear the, quote, physical and psychological burden of pregnancy, but isn't the alternative asking her to bear the psychological burden of ending an innocent life? And if we're weighing trauma, shouldn't we consider testimonies from women like Rebecca Kiesling, who were conceived in rape yet advocate for their own right to have existed? You suggest that lack of universal secular support represents systemic policy failure, but doesn't this actually strengthen the pro-life position by acknowledging that society should provide comprehensive care rather than offering death as the solution to difficult circumstances?
You are questioning whether moral evaluation is fundamentally about intention, yet isn't the entire concept of human rights grounded in the intention to prevent suffering and ensure dignity? You ask me for a specific peer-reviewed study, but that's an unrealistic demand for a live debate. And more importantly, it's a diversion from the widely accepted psychological consensus, which is that denying a wanted medical procedure and bodily autonomy causes a significant and measurable increase in psychological harm. You cite Rebecca Kiesling, yet are you suggesting that a single anecdotal case can outweigh the countless voices of survivors who advocate for their right to choose? Her experience, while tragic, is a personal testimony, not a universal prescription. You argue for comprehensive care, but you offer that as a hypothetical solution, not a present reality. What value is a pro-life position that provides no real-world solution to the physical and psychological crises you yourself acknowledge?
You just claimed that human rights are grounded in preventing suffering, yet you're advocating for a procedure that definitively ends a human life. So if preventing suffering is the standard, why doesn't the permanent suffering of death outweigh temporary psychological distress? You dismiss Rebecca Kiesling as anecdotal while simultaneously invoking countless voices of survivors, but where is your evidence that these countless voices represent a majority? And isn't your own argument equally anecdotal without the peer-reviewed studies you claim are unrealistic to demand? You assert there's a widely accepted psychological consensus about denying medical procedures, but are you conflating elective abortion with genuine medical necessity? And can you name the specific psychological organizations that have declared abortion a medically necessary treatment for rape trauma? You accuse me of offering hypothetical solutions while providing no present reality, yet isn't your position demanding the immediate availability of killing as the primary response to crisis, rather than working to build the comprehensive support systems we both acknowledge are needed?
You just conflated the prevention of suffering with the prevention of a human life coming into existence. The core of my argument is not that death is a desirable outcome, but that forcing an individual to carry a pregnancy against their will is a violation of their bodily autonomy. You dismiss Rebecca Kiesling's testimony as an anecdote while simultaneously invoking countless voices of survivors, but where is your evidence that these countless voices represent a majority? And isn't your own argument equally anecdotal without the peer-reviewed studies you claim are unrealistic to demand? You claim there is a widely accepted psychological consensus about denying medical procedures, but are you conflating elective abortion with genuine medical necessity? And can you name the specific psychological organizations that have declared abortion a medically necessary treatment for rape trauma? You accuse me of offering hypothetical solutions while providing no present reality, yet isn't your position demanding the immediate availability of killing as the primary response to a crisis, rather than working to build the comprehensive support systems we both acknowledge are needed?
You just accused me of conflating prevention of suffering with prevention of human life. Yet, isn't your entire bodily autonomy argument doing precisely that, treating the elimination of an existing human life as equivalent to preventing conception in the first place? You claim I'm demanding killing as the primary response, but aren't you the one insisting that ending a human life should remain legally available rather than prioritizing the comprehensive support systems we both acknowledge are needed? You invoke bodily autonomy as absolute, yet if this principle is truly inviolable, why do we legally require parents to use their bodies to feed, shelter, and care for born children against their immediate desires? And isn't pregnancy simply the earliest stage of this same parental obligation? You challenge me to name psychological organizations supporting abortion as trauma treatment, but can you name any major psychological association that has declared forced pregnancy more traumatic than the deliberate ending of one's own child's life? If bodily autonomy is your foundation, are you prepared to defend a woman's right to use alcohol and drugs during pregnancy, since restricting these also violates her autonomous control over her own body?
You claim that my argument conflates preventing suffering with ending a human life, yet you fail to distinguish between the moral weight of preventing a potential life and the moral weight of forcing a person to carry an unwanted pregnancy to term. The core of my argument is that no one can be forced to use their body to sustain another life. You assert that I am the one demanding killing as the primary response, but aren't you the one who is demanding that the law make abortion illegal, thereby forcing women to carry unwanted pregnancies to term, even in cases of rape and incest? You also claim that parental obligation to a born child is the same as pregnancy. If that's true, then why don't we see the same level of legal and moral debate about forcing a parent to breastfeed or donate a kidney to their child? Finally, you challenge me to name psychological organizations that declare forced pregnancy more traumatic than abortion, but are you prepared to provide any evidence that the majority of women who have abortions suffer more trauma than those who are forced to carry unwanted pregnancies to term?
You're right that I advocate for legal protection of unborn life, which would restrict abortion access. The distinction I draw is that pregnancy represents a unique biological relationship where one human life depends entirely on another, unlike other forms of dependency. While we don't legally compel organ donation or breastfeeding, pregnancy involves a life that already exists and naturally depends on the maternal environment. It's not creating new dependency, but protecting an existing one. Regarding psychological trauma, I acknowledge that research shows mixed outcomes for both abortion and carrying unwanted pregnancies. The American Psychological Association has noted that mental health outcomes vary significantly based on individual circumstances, social support, and personal beliefs. Women with strong religious or moral convictions against abortion may indeed experience greater trauma from the procedure, while others may experience relief. However, from a Catholic theological perspective, the psychological well-being of the mother, while deeply important and deserving of comprehensive support, cannot override the fundamental right to life of the innocent unborn child. The Church's position is that society must work to address the root causes that make pregnancy seem unbearable: poverty, lack of support, social stigma, rather than offering death as the solution to these social failures.
Before we turn to our AI judges for the final verdict, each debater will deliver short closing statements.
We must base our laws not on abstract theology or a biological moment, but on a consistent, rational framework that respects human dignity and bodily autonomy. Viability, while imperfect, is the most coherent legal standard, as it marks the point where an organism can survive independently. To do otherwise would be to deny a woman's fundamental rights and create an absurd legal system where a person's worth is determined by location alone. We must protect the rights of the living, breathing individuals who are capable of independent life.
Life's beginning is not a matter of shifting technology or location, but of fundamental biology. At conception, a genetically unique human organism begins its continuous development, and its inherent dignity cannot be denied simply because it is dependent. To argue otherwise is to create an arbitrary standard that devalues life based on its size or location. We must stand for a consistent moral and legal framework that protects all human lives from their very beginning, because every person has intrinsic value.
Let's hear from our panel of AI judges one final time as we wrap up the debate. The score these models gave to the human rights attorney for the final round is as follows. The scores assigned by the models to the Catholic theologian in the final round are as follows. Here are the scores from a 3-round debate between a human rights attorney and a Catholic theologian. Today's debate ends with the human rights attorney taking the win. We hope you enjoyed this clash of ethics and biology as much as we did. Stay tuned for more debates and let us know which side convinced you most in the comments below. Thanks for watching.